Good morning.
Good morning.
Welcome to another oral argument session of the 5th DCA. As a reminder, we are being broadcast live on YouTube and recorded. The next case that we have on our docket is case 20-2522, Bathke versus Bathke. Because there's a cross appeal, I have set the clock for 25 minutes for each side. If you could combine your arguments into the time that you're allotted. And Mr. Tyson, once you're up, if you could indicate how much time in that you'd want for rebuttal. I'll quickly introduce the panel. I have Judge Wozniak on the panel today and also Senior Judge Jacobus. And with that, Mr. Tyson, you may proceed.
I'll ask for just 5 minutes in rebuttal, Judge.
Okay.
If I'm ready, may it please the court. May it please the court, I represent the appellant Ben Bathke in this case. The first issue that's on appeal is this issue regarding the tax consequences regarding the parties' two business entities. During the trial, well, actually before the trial, the parties entered into a marital settlement agreement, which basically liquidated what the tax consequences would be upon a hypothetical sale of the two business entities. And it was like $309,000 or so, give or take. And so at the trial, we really were sort of just posing to the judge what basically a legal question to some extent on whether the hypothetical tax consequences associated with a sale of this entity, would those be considered an equitable distribution? And as we stated in the trial court, and as we stated in our brief, there's a whole long line of cases that talk about how the court it must consider potential income tax consequences when dealing with issues of equitable distribution.
And most of those cases remand for consideration. And so what do you think is the proper outcome here, where in the oral ruling on this topic, the court said, I have considered the tax implications, but I find that the evidence, the bottom line is that the businesses aren't up for sale in an imminent way, is it pending? And so this is a little different, right? Because the court clearly considered the tax consequences and made a determination.
I'm sorry.
Go ahead.
No, she considered them, and what she found was the basis of the judge's ruling was that there wasn't an imminent sale, meaning at the time of the trial, the husband didn't say definitively, hey, this business is going to be sold tomorrow, or that there's a sale pending. There was no definite imminent sale. And so the judge's reasoning is sort of not in line with the slew of cases that talk about potential income tax implications. I mean, I can go through the cases your honors have already read.
Was that error brought to the trial court's attention either through rehearing or otherwise? In other words, your argument was you need to consider them, and she says I have considered them. I feel like I'm bound by this doctrine. And then I guess, could you address the preservation argument, whether that secondary argument, more specific argument that you're not constrained in any way by this imminent sale doctrine, whether that argument was raised?
Well, before the trial, I actually, because I had handled the trial, and so I'm familiar with what we had filed. We filed a very long memorandum of law, which we raised that issue and cited all these cases and said, no, the imminent sale doctrine, if you would call it, is not applicable in this case. What the case law says is that potential, contingent, possible tax considerations are to be taken into consideration, even tax consequences that may never occur. And so to address your issue, Your Honor, we presented that issue in a very long memorandum that I had wrote and presented to the court prior to the trial. I asked the trial judge if she had read that memorandum. She indicated she did. I asked her if she was familiar with the case law that I had cited in the memorandum, and I think I argued some of it during the trial. I don't remember the particulars. So that issue was properly raised before the court, that the basis, and really the basis of her ruling not only was this imminent sale doctrine, but she kept citing to this England case that the wife's counsel had brought up. That was another basis for her ruling. And I was very clear, both in my memo and during my oral presentation during the trial, that case had no applicability here. The England case just did not stand for the precedent of the issues that are before the court. So I believe we properly presented that issue before the court, and the court trial court sort of went with that imminent sale doctrine, which, like I said, is sort of completely contrary to Florida law on the issue. There are just so many cases that talk about contingent tax liabilities. The cases I've cited talked about situations where tax may never occur. How about the normal situation where you see in divorce cases, tax considerations being taken into consideration are the context of retirement accounts. It's customary that if one of the spouses has an IRA or has a 401k or some sort of tax deferred plan, that you take those tax considerations into effect, and when you're doing the equitable distribution, that is sort of just the general law. That's the way it's done. With retirement accounts, it's all speculative. The future is completely speculative as to when.
Would you agree, though, that in determining the fair market value of an asset, is that me? Y'all hear that echo? Okay.
Yeah.
Would you agree that in determining the fair market value of an asset, and specifically a closely held business, that a trial court has discretion in whether or not to include a specific value for potential tax consequences when determining what the fair market value of a portion of that asset is?
I think if the evidence is presented to the court, and this is what some of the case law talks about, that it's error if an accountant or if there's other evidence before the court as to what the tax consequences, under those circumstances, I think the court has to follow the law. So it has discretion in the sense of if, hey, husband and wife, you didn't put on the proper evidence to give me a determination of what those possible tax consequences are. Therefore, I couldn't value them, and therefore I cannot include them. In the particular case, we stipulated to that number. So we already did for the judge the evidence portion of it. We gave her a number. We said, these are what the tax consequences are. We stipulated to it in the settlement agreement. So like I said, our position is that this was just a legal argument for the court. The experts, both parties had experts, and we have a number that was stipulated to in our marital settlement agreement. And the issue is whether this hypothetical tax obligation is to be considered. And I think it's important for the court to understand that both parties had experts that valued the businesses. And much like in many divorce cases, you've got experts that value a business. And when you value a business in a divorce case, or in many cases for that matter, you're coming up with a hypothetical sales figure. The whole thing is hypothetical. You're basically assuming that there's going to be a reasonable buyer and a reasonable seller, and this is what the number is going to be. And so to me, I don't see a distinction at all between a court coming up with a fair market value number, which it does all the time, which is based on hypothetical facts that may or may not happen, versus a tax number that is also in a sense hypothetical. Now, the tax number actually to some extent is less hypothetical because it was calculated by experts based on tax law and stipulated to. So the only issue, the only sort of contingency in this case was when the tax implication would hit. The expert at trial testified there was no way the husband could avoid a capital gains tax. If he sold his interest in the business, he couldn't defer it. It was going to happen. So if you look at the line of cases that talk about IRAs and tax consequences associated with notes and mortgages, those cases talk about potential tax consequences and those being considered. In this case, it's going to happen. That's what there was no counter evidence to our expert at trial that said if he sells the business, there is going to be a capital gain, and this is what it's going to be.
Why
so
was it not just
sorry.
Go ahead.
If we were to find in your favor on this and reverse and remand, what would our remand instructions to the trial court say?
I think it's very simple. I think we just have to amend the portion of the final judgment that talked about the equalizing payment, because we've already liquidated the damages. That's why I made this thing, the goal, and what ended up happening was to kind of make this thing pretty easy. This is the number, the 304 plus number. So to answer your Honor's question, if you remand or you reverse and remand, all the trial court has to do basically is amend the judgment and change the payment plan. Because basically,
so your argument is really that the trial court erred in not providing essentially a credit for the tax amount, not that the trial court erred in failing to consider it.
Well, no, the original amount the party stipulated to was 1.2. That's what the husband was going to pay her over 10 years. And then the agreement said if the wife prevailed on the issue, she gets an extra 300. It becomes 1.2 now, becomes 1.5, and then the court will decide how to deal with it. So if your honors reverse, then it goes, basically it's real simple, it goes right back to the agreement that says the wife gets 1.2 over 10 years.
Why, if we look at this from an abuse and discretion standpoint, isn't it just that your client failed to meet its burden of determining that the tax implications needed to be included in the consideration? There was evidence that whatever the capital gains rate was unclear, that it was unclear when the sale would occur, that, he hoped to retire in 5 years, but it wasn't necessarily certain that he would retire in 5 years. If all of these elements that were presented to the trial court were in maybes and potentially, and we assume, why is it an abuse of discretion to not include the tax implications in the fair market value of an asset?
Because, well, one, I think we stipulated to the number. So the issue of needing evidence on the number of the actual tax implications themselves, I think that we already sort of set that up for the court. The case law says, and if you follow the case law, it says potential, inevitable. I mean, the Sunland case, which is a 5th DCA case from pretty recently, from 2020, talks about that the purpose is to ensure one party is not charged with the full value of asset burden with inevitable payment of taxes to avoid an unfair advantage. None of the cases say you have to prove with absolute specificity exactly when the tax is going to occur, how much that tax is exactly going to be. And like I said,
no, they don't say that, but I'm struggling. If our standard of review is abuse of discretion, and if it's within the court discretion to consider these factors, that's what I'm trying to see is there cases that say it must in those circumstances where it's speculative.
Well, I don't think it's an abuse of discretion standard. I think the court misapplied the law. The court applied the imminent sale doctrine and said the reason I'm not considering the tax consequences is because there wasn't an imminent sale pending. And that's not the law in Florida. The law does not require an imminent sale in order to calculate tax consequences. And again, all the different situations with IRAs and all that sort of stuff, they're never imminent situations where there's payment of tax. So I think to answer your question very directly, Your Honor, I don't think it's an abuse of discretion situation. I think facts were presented, they were stipulated to. She had to make a ruling of law, and our position is that the court applied a doctrine and a method of law that's incorrect, which would be a de novo standard.
So in that case, we would remand for additional consideration then.
I think, right? Well, I don't think we'd have to remand for additional consideration. I think we'd have to remand to reverse the ruling that the wife got the extra 304, and the ruling would be we reverse. The court should have taken into consideration the tax consequences, and as per the parties' agreement, the wife doesn't get the 304. It goes back to the 1.2.
Just because of the stipulation, or because you think the trial court does not have the discretion to exclude tax consequences from the fair market value of an asset in these circumstances?
I think my position is that we framed a legal issue to the court, and not only did we frame a legal issue to the court, but we sort of told the court, okay, which way you decide the legal issue was going to be the result. It's real simple. If tax consequences are taken into consideration, then the husband doesn't pay any more money. If tax consequences are not taken into consideration, then the wife receives the 304. And she determined tax consequences are not applied because of the imminent sale doctrine, which is clearly wrong, and therefore, then I think the position is that the decision of the trial court has to be reversed. And to answer what Judge Wozniak said, I think it's a real simple one on a remand. The judge just has to change the final judgment.
There's no question that when there's a sale of the stock at some point, 5 years, 10 years, 2 years, it's burdened with the tax, capital gains tax, correct?
That's absolutely correct. Yes, right. And that's to our point. It could happen 1 year, it could happen 5 years, it could happen 10 years. And the case law says it doesn't need the imminent.
I guess if he died, they get a stepped up basis, whoever got it, but that's about the only way.
Yeah, that could be you're right. I didn't bring that up, but yeah, absent those circumstances. And that's what our expert said at trial. Our expert said at trial, it's the same thing the judge said. doesn't matter when it's sold, you're going to have tax consequences, much like you're going to have tax consequences in all these different situations. If it's all right with your honors, I sort of wanted to move to our second point or issue on appeal regarding the award of attorney's fees to the wife. If that's all right with your honors. Basically, the second issue is the wife in this case, after we had the original trial, which involved the tax consequence issue, the wife, we had a reservation of attorney's fees, and the wife ended up receiving at a subsequent hearing 100% of her attorney's fees. This is despite the fact that she received in the divorce about $2.8 million in assets, an annual income of over $100,000. There was absolutely no evidence presented at the trial court level that the wife had a need. The trial court's ruling basically said that the wife had struggled to make payments and that she was receiving alimony of less than $1,000 a month and equitable distribution payments of $10,000 a month. Those court findings were completely unsupported by the record. The simple one, the judge found that she was receiving $10,000 a month and equitable distribution was wrong. She was receiving about $16,000 a month rather than $10,000 a month. The $16,000 a month was the equalizing payment on the 1.5 that we talked about. So the judge, we believe, when she was making her ruling as far as need, was clearly operating under an incorrect premise. A $6,000 a month incorrect premise, $72,000 a year incorrect premise. That's the first issue too. The wife did not struggle to make her payments. The wife did not have to borrow money to make any payments. The wife did not present any evidence that she had to even dip into any of her assets that she received to any extent. But I think the rule looks like the ruling sort of focused in on the fact that the husband had a superior income than the wife. The wife's income from all her sources still exceeded over $100,000 a year.
Is this a reweighing the evidence issue when we have a finding from the trial court that she's demonstrated the need, that she struggled to make payments, even though she paid the bills as they came in? There's evidence in the record that, or determination in the record that there's a $2,100 shortfall, that initial chunk that she removed from the party's account was included in the equalizing payment. That there's testimony that the amount that was withdrawn was settled in the party's distribution plan. When we consider all of those little pieces together, isn't that a matter within the trial court's discretion?
I mean, the trial court has a discretion on determining the wife's need, but there was a lot of hard evidence in this case that was sort of undisputed. I mean, that like your honor even brought out, these financial numbers are hard numbers. And so there really isn't a whole lot. I mean, I think it's easy for an appellate court, not reweighing the evidence in the sense, because it's not credibility issues. Or really, these are just hard numbers. And the court, I think, has to look at this and say, was this an abuse of discretion in awarding the wife 100% of her attorney's fees when she received so much? To answer your questions, there was not a $2,100 a month shortfall. I know that was cited several times in wife's brief. That's not correct. That's not what the evidence showed. In fact, the wife's expert, Mr. Gallagher, he testified at both the trial and the attorney's fees trial, and he testified her shortfall was about $600 a month. But that's what he testified to. The trial court actually, and it's an alimony award, the court did quantify how her alimony award was to be taken into consideration. The court quantified her need, quantified her sources of income, and then used alimony to bridge the gap. And the alimony ended up being, I think, $943 or something like that. So she did not have a $2,100 a month shortfall. That's just something they put in their brief that's just not supported by the record. And as far as the original payment, when the parties split, that kind of goes right to the issue of need. When the parties split, the wife took it on her own. This is undisputed. This wasn't really something we really got into, as far as a disputed issue. The wife took $325,000 from a joint Wells Fargo account and left the husband $160,000. The wife then took from the $325,000 she paid $125,000 in fees and costs to her attorney, Mr. Mason. That $125,000 was more than what the husband paid all his attorneys and his expert throughout the course of the case. So the question is, and the other side made the argument during the trial, and there's no real evidence of it, that somehow the 325 and the 160 was kind of thrown back in the wash and was part of the agreement. They say that, but the settlement agreement doesn't even address that. But regardless, the issue is,
Wasn't that testimony by though? I mean, isn't that testimony that I don't know why it's doing that, sorry. Isn't that testimony that the trial court could have accepted, that was included back in the parties' agreement?
Well, the testimony, I believe what you're referring to, was from the expert. The expert wasn't a party to the settlement agreement. The agreement speaks for itself. I mean, that's if there was an ambiguity in the agreement, then maybe, you can get into some parole evidence. But the question of whether 325 and 160 was thrown back in, that's not addressed in the agreement. The agreement said this is what the wife's
was that objected to? Was that testimony objected to on that basis below?
To my recollection, it was.
If you want to look for a record site on that in your rebuttal.
I'll try to look for that site, but I remember bringing up that point, and even, I guess taking it further from that point, assuming for a second that was even true, that it was thrown back in the wash. The issue is whether she had the need, and did she have a similar ability as the husband to retain competent counsel? The reality was she took money, 325, which was marital money, even though she took a lot more, still marital money, and she took it and paid her lawyer and was able to then basically pay a fee that exceeded the husband's fee throughout the case. So to claim that the wife didn't have the need really just doesn't make any sense when she had that kind of money right off the bat and paid that large fee. I'm not, I think the issue in this case, what we appealed is that, she was given 100% of her fee. The case law, and there's a bunch of cases that we talked about in our brief, to talk about in circumstances very similar to this case, courts have either said, have either affirmed no fees, or they've said 100% of fees are improper. Just recently, there was the Eldridge case. That was a 5th DCA case out of 2014 that actually affirmed that said there was a denial of fees to the wife. And the reason they denied the fees to the wife was because equitable distribution had been affected outside of the award of fees. In Eldridge, the wife had a net worth of $3 million and was getting annual income of $130,000 a year. And this appellate court said no fees. Our circumstances of this case are very, very similar. The wife, in our calculations, I think received $2.8 million in equitable distribution, and her income is a little bit over $100,000. So
you have about 3 minutes remaining if you want to reserve that.
I will reserve that, Your Honor. Thank you.
Sorry about the feedback.
Thank you.
Ms. Newell?
May it please the court, Erin Newell with Florida Appeals for the appellee cross appellant Mary Elizabeth Costley, formerly known as Mary Elizabeth Bathke. Judge Sasso, may I reserve 2 minutes for rebuttal on the cross appeal?
If you could combine both of your arguments into this time period, and then
I will. Thank you, Your Honor.
One rebuttal. Mm-hmm.
I understand. Thank you. I want to start in the same place that the former husband did with this issue of the tax consequences or tax consideration regarding the businesses that the former husband owned. And those were PEC, and then there was a real estate issue with another business, BCB was referred to in the record. So first of all, this marital settlement agreement, the matter was resolved. All of the assets were considered with regard to equitable distribution. And one of the first assertions of fact that the former husband makes to this court is that the court actually had agreed to a liquidated number that represented this taxable capital gain. And that's just not the case in the record. What the parties did stipulate to for the purposes of moving forward. And this, if you look at the former wife's pretrial memorandum, is very clear. That's at page 136 of the record. They agreed to a fair market value of the business. This was not for the purposes of trying to predict a hypothetical tax consequence in the future. It was the purpose of reaching an agreement on the equitable distribution of the assets.
You agree there is a tax consequence in the future if you sell the stock, correct?
Your Honor, that was the question that the parties decided to defer to the court. And it's our position that it is a question of fact.
The court doesn't get to decide whether there's taxes or not taxes. I mean, when there's a sale of a closely held corporation like this, there's going to be a capital gains tax. I think everybody agrees with that, don't you?
Judge Jacobus, respectfully, the court does need to decide whether there is a recognizable capital gain. And that is what the first
seemed to say. Look, I mean, I think the judge understood there is a tax consequence. What the judge said was, look, there's no imminent sale, so I'm not going to deal with it. I'm going to just let her go. But I mean, but we all know that at some point, if there is a sale, there is a tax. So I mean, it seems like she kind of thought that because there was no sale imminent, there's nothing in the record that says that, other than, I guess he said, I'd like to sell it in 5 years or I'm going to retire. But whatever it is, it decided not to deal with the tax consequences, correct?
And Judge Jacobus, respectfully, I disagree with Your Honor. I would direct Your Honor to the record at page 1185. That's where the judge made her oral pronouncement of how she was ruling at that time in real time. She speaks for 2 pages of the record. So she's about discussing this for 2 minutes, where the former husband's counsel did again reiterate all of these legal standards. And the fact of the matter is, the court did not apply an imminent sale doctrine. The court did consider the evidence. The court did make a ruling that, in the court's estimation, based on the discretionary ruling, she did not see a recognizable capital gain at that time with any specificity that could be tax impacted at that time. And it's interesting, the former husband's expert actually was called on to testify, and the former husband's counsel tried to direct
if we can go back to her oral ruling,
Yes,
is that really a accurate characterization? Because she does say the bottom line is that, are these businesses up for sale in an imminent way? Is it pending? So doesn't that pretty clearly reflect, especially when you combine that with the explicit finding in the final judgment, that she was under this impression that unless there is evidence of an imminent sale, that she cannot account for any potential tax consequences?
Your Honor, I think at lines 16 through 25 on page 1185, the court does state, I understand Mr. Bathy's testimony. He is going to retire at some point. There is a buy-sell. He has to first give the opportunity to be bought out by his partners, but that's going to be something that happens in the future. It's not something that's imminent, as the case law states. So I take the position of the petitioner that this equitable distribution amount, and then obviously, is not recognizable. And again, I will direct the court to Sumlin, which Judge Sasso did mention. These cases are remanded for evidentiary hearings, and that's exactly what Sumlin did. In Sumlin, there was no evidence presented. The court declined to consider evidence. Here, very clearly, there was extensive evidence given by the former husband's expert and the former wife's expert regarding these hypothetical or non-recognizable tax gains that would eventually occur. But Sumlin does also cite another case by this court, Vaccaro, which is a 1996 case out of the 5th DCA. And Vaccaro rejects the husband's complaint that the value of the stock awarded to him must be reduced to reflect speculative or possible future tax consequences. And really overall, I think what the case law demonstrates is that these are highly fact-intensive matters regarding whether, especially when we're involving stock. And again, I would direct Your Honors to the former husband's expert. And he talks about that different types of sales being possible when it comes to these type of assets. And frankly, the former husband owned stock. He did not own the asset entire. He owned something like 83% shares of stock in
well,
this
what is your
company.
response to the argument that number, assuming that the trial court was willing to account for tax consequences, that number was solidified by the parties for the stipulation? So all the court needed to do was recognize the tax implications matter and then apply the sum agreed to by the parties.
Your Honor, I am not recognizing where there's a stipulation in this case.
Well, wasn't the issue presented to the court if if the court may consider tax consequences, then the numbers, 304, whatever the case may be.
Yeah, 304.
Trying to find that page of the record.
And I would just refer back to the actual agreement, to what it actually says. So in the record at page 181, that's where the equitable distribution is discussed in the parties' marital settlement agreement. I'm sorry, there is actually language specifically about that. It's not where I just cited you to. But let me pull that up, because I do think it's very important what the parties actually agreed to. And if I may, it is very clear, especially again in the formal wife's pretrial memorandum, that there was not a stipulation as to the consequences. It simply wasn't the case. The stipulation was for the purposes of agreeing to an equalizer payment that would be paid to the wife. And the record site, for your honors, is actually 186, paragraph 12K of the pretrial marital settlement agreement. Talks
So I'm
specifically
looking at
about
the
tax
final judgment.
consequences.
And I think you're right that more precise language would be the amount of the equalizer payment rather than the amount of the tax consequences. But it looks like the trial court on page 3 of the final judgment says, on the other hand, if the court determined that the tax consequences could not be considered, then respondent would owe, and then that amount. So it seemed like the only issue that the trial court was weighing was whether or not she could account for tax consequences. And I mean, would you agree that a trial court has the discretion to account for tax consequences and is not prohibited from doing so under an eminent sale doctrine?
Absolutely, Your Honor. And I think this court's decision in Vaccaro exactly proves that point. It affirmed the court's discretionary decision not to assess in a stock situation just like this. The sale of stock is completely different than the other situations that are mentioned by the former husband, such as pensions, 401ks, and retirement accounts. And quite frankly,
why is it different?
Because the purchaser, and this actually, Your Honor, I am not an expert in this, but the former husband did present expert testimony on this. And I would direct the court to the experts.
And you said that sale of stock is different than a 401k or an IRA or whatever. I mean, what do you think the difference is?
Because with the business, there are different options. With a pension, and there are actually more than one difference I'll bring up. With 401ks, retirement accounts, pensions, the tax impacts are built into them. And many times, in many of these cases, in fact, when you look into the specific situations, the tax impacts are actually occurring. And that's something that England mentions, the first district. It takes into effect that there were no tax benefits taken by the parties during the marriage. So in the case of a 401k or specifically a retirement account, when the parties invade those assets, there are tax consequences immediately, whether they wait until retirement or not. A lot of the cases cited by the former husband involve situations where tax penalties were occurring in real time.
Tax consequences.
But they were imminent because they were happening.
Tax consequences.
But the issue is, and I apologize, Judge Jacobus, I am sorry for cutting you off. The fact of the matter is, and this is something that the former wife's expert testified to, there is no capital gains tax until the sale occurs. In pensions, in retirement accounts, there are tax consequences, okay, when these assets are invaded. So that is a difference. And also there are different options to purchase these type of assets, which is what the former husband's expert testified. And he actually testified to a sale of the entire asset, which is impossible in this case. So if we do get a little bit closer into the evidence and see what the testimony was that this could be sold as an asset in full to make it easier for the buyer, but it actually couldn't be done. The buy-sale agreement is clear in that. The trial court mentions the buy-sale agreement in iterating her oral argument when she was ruling on this. And for those reasons, this court should not invade the trial court's discretionary ruling that that asset should not be tax impacted for the purpose of the equitable distribution award. Moving on to the attorney's fees issues on the.
Can you actually address the interest argument? In your brief, I believe you conclude that the attorney's fees award is not a judgment for purposes of the statutory interest rate, and therefore it wasn't error to include what appears to be kind of clearly the wrong statutory interest rate. Can you expand on that argument a bit?
Yes, Judge Sasso. So there was initially an order that did seem to employ a statutory interest rate that was incorrect, and we do concede that. However, on rehearing, the court entered a new order, and that order on rehearing is in the record at page 709. The court very clearly does not attempt to apply a statutory rate of interest. In that order on rehearing, the court actually grants in part the former husband's request to create an installment plan. Installment plans are not judgments. Case law is clear on that. So in creating that.
And I
Yes, Your
saw
Honor.
that you say the case law is clear, but I didn't see a citation after that sentence in your brief. What case do you think stands for that proposition?
Yes, Your Honor. So it is not a 50 CA case, but there are a decent amount of cases out of the Second District Court of Appeal. Lowman versus Lowman, which is a 1999 case out of the Second District, states that the trial court has discretion to establish a regular payment plan, which transforms the attorney's fees into an installment promissory note. So that's the proposition there. In terms of creating a promissory note in the context of an alimony award, the Second District again stated that the court was not required to use a statutory rate of interest with regard to an alimony note, which is similar in those circumstances.
Isn't that particular to distribution, though, to the statute?
But this was an attorney's fee award. So I suppose, if I'm understanding, Your Honor, the statute at issue is 6116. And were this a judgment, that would be correct. However, the former husband is the one who actually requested that the court vacate that judgment and enter a new order. And that's what the court did per the former husband's request. The court did, in fact, create an installment plan because the parties couldn't agree amongst themselves. And in that installment plan, the court decided to keep the 6.33 statutory interest rate. And again, I really can't impress upon the court enough that the court took out the word statutory. Very specifically, you have to assume that the court intended to do that. And that's on 709 of the record. Actually, if you look at page 710, which is the amortization chart, it identifies interest rate and applies the 6.33. It doesn't purport to apply a statutory interest rate as is argued by the former husband.
From the way I view the record, the court enters the initial order and then states on the record that that's the only part of the order that I'm amending, such that interest rate is still applicable. So you think
the
that
6.33?
Yes.
Yes, I think the court didn't really care whether it was statutory or not, and it doesn't have to.
Well, I know you think that, but where are you where are you getting that from the record? That she somehow decided that the court was no longer going to be using a statutory rate and was instead applying a discretionary rate of 6.33.
From the former husband's motion for rehearing, that's what the former husband was requesting that the court do, is to create an installment plan. And the court went ahead and exercised its discretion to do that. And as far as the court's prerogative to apply a statutory judgment interest rate or not, again, I would point to an analogous type of case involving.
So you think
alimony.
anytime a judgment has a deferred payment plan within the judgment, that judgment is taken out of the purview of both 5503 and 68701 that are statutes that specifically say when interest shall accrue without a contract, the rates as provided for in 55.03.
Yes, and those statutes refer to judgments, and that's the basis of the argument that this is not, in fact, a judgment any longer. When the court does grant a request to create an installment plan, it becomes a promissory note. And that case law out of the second is very specific on that issue. And again, Cotton versus Cotton says essentially that in the context of alimony award, that the court is not required to use the statutory judgment interest rate established under section 5503. And this court should follow that persuasive authority when considering this, that the court clearly did intend. And
I'm still not seeing in the
frankly,
cases from our court where that was the case, though, it was all pursuant to 67.075, which specifically allows for discretion in the interest rate and equitable distributions.
again,
Sorry,
I
go ahead.
apologize, Your Honor. I would just again point out that this is an attorney's fees award that was reduced to a promissory note. So it may take it outside of that particular statute. And also, I didn't see that statute cited by the former husband. Quite frankly, the former husband's argument
No,
was
it's just a
very
basis of distinguishing case law.
understood, Your Honor. Once again, our position is that this was a attorney's fee award. The former husband requested be reduced to a promissory note with interest, and it was, and the court had discretion to do what it did. This court should not invade the court's discretionary decision to apply that interest rate, and that should be affirmed.
Did the husband request that interest rate that was included? Where did that interest rate come from?
I cannot point out off the top of my head the exact place that interest rate did come from. There had been discussion in various parts of the record. I think there was an interest rate identified in the premarital settlement agreement, perhaps. But again, Your Honor, I do not want to do the disservice of guessing, so I don't know off the top of my head where that interest rate came from. But again, the former husband hasn't argued that the court abused its discretion in employing that interest rate. That's not the issue on appeal. The issue on appeal, the former husband has presented, is it felt that the court made an error of law, essentially, in not applying the statutory interest rate. And I would implore the court to follow the Second District Court of Appeal in deciding when an installment plan is created for an attorney's fee award, that this court allow the trial court to exercise its discretion and decide whether it feels the statutory interest rate should or should not be employed. Excuse me. So moving on to the evidentiary issues that go into a 61.16 fees award, there's really two major parts of the fees award. There's the requesting party's need and the other party's ability to pay. That's one part. And then if the court finds those elements are present, then the court will look to the lodestar amount regarding the reasonableness of the attorney's fee and the reasonableness of the amount of fees requested. Starting with the former wife's need, there are some statements that the former husband has made in his presentation to this court that are not accurate portrayals of the record in our estimation. As far as the shortfall that was testified to by the former wife's expert, a forensic expert, I would specifically direct this court to Exhibit 6 that was entered into evidence on the first day of those evidentiary hearings. That's at page 1757 of the record. And there the expert very specifically articulates what his analysis is and what his conclusion is that shortfall amount was there. In terms of the judge having some sort of misapprehension regarding the full amount of the note payments on the distribution award, that's addressed in our initial brief. Clearly, the $10,000 amount was principal. The judge's reasoning and understanding is articulated throughout the record at the hearing. The judge was very forthcoming and articulate about what her understanding was. And the real problem with the former husband's position is it ignores something that's been in place in Florida courts since Kanakaris in 1980. And that's the fact that the parties have to be on equal footing, essentially, have to be at least in the same arena as far as being able to retain attorneys to represent them in this matters. And Kanakaris specifically affirmed a trial court's decision and held it was not an abuse of discretion to award fees to avoid an inequitable diminution of the fiscal sums granted. And a more modern articulation of that ruling came out of the Fourth District Court in Margulies. And in Margulies, there was a really similar argument by the party that was obligated to pay fees. The party really emphasized, look at how much the requesting party got in the equitable distribution. Look at all of these capital assets that she now has. She should not, have her fees awarded to her. But Margulies actually reversed the trial court and found the trial court did abuse of its discretion in awarding only one half of the wife's fees based on that argument. And the reason that the court reversed the Fourth District, it explained that if the trial court was using those equitable distribution assets as the former husband suggests the court should have done here, this would actually decrease the amount of income they were generating. It would constitute a diminution of the fiscal sums that were granted as per Kanakaris, and that is not permissible. It is actually an abuse of discretion to do what the former husband has suggested he should do here. Also, the former husband relies on Eldridge out of this case, the 5th DCA 2014 case. And there, the court actually found that the requesting party had a net worth of $3 million. Okay, the requesting party in that case had $130,000 in annual income, not affected by the equitable distribution, Your Honors. So to suggest that this case involves a requesting party with a net worth of $3 million is disingenuous. There was no evidence of the former wife's net worth put in this case at all. What was put into evidence is sufficient to support the trial court's decision that the former wife did have a need for the purposes of 6116. Moving on to the various challenges that the former husband raises about the lodestar amount. First of all, the former wife's attorneys charged $500, that's Mr. Cheney Mason, and $350 per hour. That was Ms. Rentz, the secondary attorney. Those amounts were not challenged. They are not raised in this appeal. So those sums were found to be reasonable by this court. And that's the first step in the lodestar analysis. The second step is whether the fees charged were reasonable. And quite frankly, the arguments that are put forward by the former husband, the double billing argument, I want to just touch on it and emphasize, per this court's decision in Grover, there has to actually be a duplicity of this billable work. It's not enough to just create a demonstrative exhibit that says, oh, look, both of these attorneys were here for the same hearing. You should reduce the fee. You have to get into what the billing was and to see what the attorneys did. And this court very clearly, the trial court in this instance, did find that the attorneys both had their own specific tasks and their own roles in this litigation. And the testimony by both attorneys does support that conclusion. It was not an abuse of discretion.
Is it relevant that the husband's attorney's fees were lower than the wife's attorney's fees? Did the trial court need to take that into account?
Your Honor, whether a trial court may take that into account or not, in this case, it simply is not relevant, or its relevance is not as strong as the former husband would suggest for several reasons. Firstly, it's very clear in the record that one of the former husband's attorneys was not actually billing him when he was showing up for these, and there's no explanation as to why, but that is a fact that the other attorney was not billing the former husband. Another factor is that these attorneys for the former husband substitute appeared in a year into the litigation. So they weren't here from the beginning like the former wife's attorneys were. And the final point is something that was testified to by Mr. By Mr. Mason, the former wife's attorney, that they did all the work at the outset of this case. The forefront of this case was extremely heavy regarding taking evidence, taking depositions, getting the valuation. And Mr. Mason's testimony on that matter is in the record. It does support the trial court's award of attorney's fees to the former wife, and that award should be affirmed in all respects. Finally, a word on the issues in the cross appeal. The former wife does recall the briefing that was submitted to this court on those issues. And I'd like to reiterate regarding the alimony, the trial court's conclusion regarding the alimony really was one of law. The court essentially took 6108 subsection 2, which is extremely broad. It requires the court to consider all relevant factors, including the standard of living and any other factor necessary to prove equity.
You can very briefly conclude, please.
Thank you, Your Honor. Because of that, the former wife requests the court reverse the alimony award and remand with instructions to revise it per the evidence presented. Thank you.
All right, thank you. Mr. Tyson?
Thank you, Your Honor. One point that counsel brought up was she tried to argue that there was a distinction between a sale of a business and retirement accounts. I think Judge Jacobus brought this issue up. I just want to bring up 2 points. One, with retirement accounts, the taxes aren't incurred just because they're built in. They're not incurred and paid until the future. They're deferred taxes in an IRA. Same thing as the sale of a business. That's what the case law talks about when it talks about tax burdened assets. A tax burdened asset is an asset that has the inevitable payment of tax. So there's no distinction with an IRA, a 401k, or a business interest because it's all built-in tax that's going to be incurred at a future point. Additionally, there's 3 cases that I cited in my brief that talked about a court being required to take into consideration tax consequences in the context of a sale of a closely held business. There was the Miller case out of the Fifth that talked about how the wife was getting the home that was not subject to capital gains tax because of the exclusion of gain on a primary residence, whereas the husband was getting the business and would have capital gains. There was a Pettigrew case also out of the Fifth that also talked about that it was remanded to take into consideration tax consequences. So there's really no distinction between businesses and retirement accounts. So I think that's important. As far as the double billing, there was absolute and clear double billing. The testimony by Mr. Mason was that he was the lead attorney, he brought in attorney Rents to supplement him and to do all the things that he couldn't do or didn't have time to do. But if that was the case, then why were they billing for the same thing? During the trial in this case, Ms. Rentz's role was marking exhibits, making notes, making copies, and handing them to Mr. Mason. Now, if that's what the wife wants to hire as two attorneys, that's her prerogative. But I think to double bill and charge the husband for two lawyers that goes over the bounds of reasonableness, I think is the issue here. Now, the court didn't even get into the extent of the double billing or the block billing. The judge in her ruling simply
What
said,
is block billing? What is block billing? I never heard that.
block billing.
What is that?
Sure. What block billing is you basically take a number of entries and you bill them into one. So you bill for attend hearing, talk to client, prepare motion, and you bill it at an hour and a half, so that you can't identify how much time was spent on each
one. Okay.
Yeah, and the reason we made a point of it is because it was so pervasive. There's like 96 hours, almost a third of Mr. Mason's time in block billing. And the court simply found it didn't happen. Well, it did happen. That's undisputed. I think the court should have at least took it into consideration and addressed its ability in the court being able to find a reasonable number of hours. The court simply just took the easy method. And I know I'm out of time, so.
Yeah, that's what I was trying to say.
All right.
All right. Well, thank you both for the argument today.
Thank you, Your Honors. Thank you very much. Bye-bye.